So the two key things that I wanted to cover, firstly, was just giving you a better understanding of liability in the construction sector. So understanding liability in the construction sector, and secondly, what liability insurance does and doesn't cover. So you understand what the liability issues are, and then also where insurance fits and doesn't fit. Just a little picture, some of you may have seen it. Certainly issues of liability there with the construction of those apartment buildings in China. Hopefully we'll never see issues as serious as that here in New Zealand. Just a quick introduction to Builtin if you're not familiar with us. Our mission, I guess, is all about helping builders and tradespeople to reduce their risk. We've been in business for 15 years and working exclusively in this sector to achieve that aim. And we do that by, with our experience, but also we've arranged tailored cover. So that's insurance that's designed to meet the needs of builders and tradespeople. And we've tried to make it as simple as possible to arrange as well and to understand, although that's harder, but certainly to arrange it so you can get the cover that you need quickly and easily. We were the first to provide cover for faulty workmanship in the New Zealand market. It was something that wasn't available and claims were being declined on this basis. So we spoke to our insurer and introduced faulty workmanship cover. And the good news is that all the major insurers have now adopted that and it's available as an extension to your public liability insurance. We're also the first to provide building professionals with cover for errors and omissions. So that's equivalent to the kind of professional indemnity insurance that engineers and lawyers, architects have for their professional advice and service that they provide. And building professionals are exposed to the same kind of issues. So that's something we introduced a number of years ago to close another loophole or gap, I suppose, that existed for builders. First, I'm going to run through the fundamentals to understanding liability, just give you a bit of a big picture so you sort of understand the framework and what sits behind it, and then you're in a better place to, work within the framework of understanding liability. So liability, by definition, I suppose, is when you are legally responsible for something. And that's really determined by three things: legislation, such as the Building Act, which sets out the rules and regulations and the laws by which we have to act. Common law, so things like negligence, which are based upon historic court decisions. And also contract law, so the promises that you enter into in a legally binding contract. And you're obliged to meet those contractual obligations. Another key point of understanding liability, and liability insurance in particular, is that there has to be a third party that experiences loss or damage. So you must be held liable by a third party for a liability policy to respond. It's slightly different for fines and penalties because there's a strict liability that's enforced there. But again, at the end of the day, all those fines and penalties under law can be contested and defended in court. So there is that test that still exists there. But fundamentally, to make a liability insurance claim, there must be a third party that is holding you liable for their loss or damage. And again, ultimately, it's their courts that decide, not you or the third party or even the insurer, about liability. If it gets to court, they're the ultimate decider. Now, often these cases will be settled beforehand, either between the parties or by the insurer. But that's the ultimate, is it'll go to court and get decided there. We talk about 4 areas of risk, so I'm just going to sort of set the scene. 4 areas of risk. We talk about assets, which you'll be familiar with. You want to insure your assets from loss. You want to also insure yourself from financial risk. So that's the potential of maybe a contractor you're working for going bust and not paying your bills. Where your business or you are exposed to financial risk, that's insurable. Your own personal income, personal circumstances, insuring yourself from illness, from loss of income, from medical expenses, that kind of thing. And finally, the area we're going to cover today, which is about liability. So trying to understand liability in the construction sector, and we're trying to give you a picture of the risk environment that you operate in, so you can make better decisions, have less stress, and be able to manage risk better in the sector that you work in. So we talk about 4 classes of liability. The first one is property damage and personal injury. And I'll cover these each in more detail in a second. Secondly, where your liability is for the financial loss of a third party only. Thirdly, where fines and penalties are involved. And finally, where there's some management liability, where your actions as the manager or director of a business result in liability. So moving to the first one, property loss or damage and personal injury. This, for example, is where someone's injured and you're responsible, or they become ill, and that could be, for example, a workplace accident, if something like a bank collapses or scaffolding or roofing iron flies off, and that could injure potentially an employee or also third parties like the public. And secondly, loss or damage to someone else's property. So that typically, from an insurance perspective, needs to be sudden and unforeseen and unintended. And for example, it could be a vehicle crash, scratched glass, or the old screw through a water pipe scenario. The second area of liability is financial loss. And that's where someone incurs or potentially will incur, and they're alleging they will incur, a cost because of your actions or inaction. And we sort of put in brackets there, a mistake that you or someone's made on your behalf, or an error or an omission, i.e. a failure to act. Something you've done that's going to result in a financial loss to someone else, but there isn't a physical, there's no physical property damage. Examples of that could be maybe a survey error, where foundations set out and laid in the wrong place, perhaps a mistake in interpreting a specification, or making substitutions which void a warranty, or a result in an inferior product being used and problems arising, and potentially liability from your use of defective materials. Thirdly, fines and penalties. So your liability for a breach of legislation or regulation, which results in a fine. The hot topics obviously are around health and safety, but common ones also include resource consent breach or building without a building consent. And finally, management liability, the fourth segment, if you like, of liability. And that's arises from allegations or liability of a director for negligently running a business. So, for example, perhaps trading while the business is technically insolvent. And if a liquidator is appointed to that business and they look back and see that the business was trading while it was technically insolvent, under the Companies Act, the director can be held personally liable and losses can be clawed back from the director. Also employment practices, so liability for things like unfair dismissal or discrimination. And as I mentioned, company directors can be held personally liable in some circumstances. So really this is about your management of the company, and those other ones are about your performance of the physical work or of the professional service. So what I want to touch on here is how to assess, eliminate, or if you can't eliminate it, to mitigate or reduce the risk of some of these things happening. And really the question to ask is, what are the potential risks of this act or this service or this advice that I'm providing? And there's three areas to think about. So the risk to people, staff, customers, contractors, the public, yourself, and health and safety legislation and all of the tools that are available do a good job of helping you to manage this and reduce this. Secondly, what's the potential risk to third-party property? For example, neighbours' property or your client's own property when you're on their site. And how do you understand or assess what potential risk is there, and then how do you manage it? And thirdly, what are the risks of mistakes that you might make, or perhaps your staff or subcontractors or others might make on your behalf? Or perhaps you're following orders, or perhaps you're the person who decides what to do or what not to do. But the risk of making a mistake, how do you assess that and then mitigate that? And this is the matrix that we use, or I guess advocate for our clients. And it's something that does take a little bit of getting used to. These are three examples, but I would urge you to sit down for an hour with some other people in the business, with some of your professional advisors, and just start to understand or list out what those potential risks are. So the way the matrix works is you have a particular risk that you've identified, and you give it a score in terms of the likelihood of it happening. And this is all gut feel stuff, because unless you've got statistics, it's hard to really assess this. But what's your gut feel of the likelihood of that kind of risk coming to pass on that particular project? And then if it did come to pass, what would be the cost? So is it highly likely to occur and very costly if it did? Well, then you've got a really high risk issue there that you need to deal with. What if the likelihood of it happening is really remote? And if it did happen, well, there's not going to be a huge cost. Therefore, the risk of it, you can put that right down the bottom of the rankings, I suppose. And that just gives you a way to start to balance and rank and identify the key risks, the ones you need to deal with. And then you can put in place a plan to achieve that. Now, part of that's insurance, and I'm going to cover that towards the end. But before you even get to insurance, and there'll be things that you're already doing in your business, it's asking the question, well, I understand what those risks are. I've ranked them. How am I eliminating or minimizing those risks? And again, with health and safety, you'll have a good handle on that, and no doubt the support with Hazard Co or someone like that. But it's about making sure they have the right skills and experience on that job or in the business. You've got good planning, good systems and procedures, good quality assurance program, the right contract in place for that particular job, and that you understand all the clauses in the contract. As I said, site-specific safety plans, other health and safety compliance documentation and processes, the right training for staff and for yourselves so that you are minimizing risk. And that's where the matrix helps, is understanding where do you need to provide training or take training. Then you've got trusted and competent staff running projects or doing the particular tasks. They've got the right project management resource and oversight involved. And also that you've got the right business advisors and consultants working for you, whether that's accountants, lawyers, architects, engineers, insurance advisors, are those people that feed in and support your business. And after all of that, where you've understood the risk and you've eliminated those risks you've identified as much as you can, that you've mitigated or minimized others that you can't fully eliminate, insurance, is really about risk transfer. So you pay a premium to an insurer who takes that risk off your shoulders, or the cost involved off your shoulders for the payment of that premium. So if something does happen, it's understanding what insurance you can put in place to cover it. And what I've got here is just some tables, which I'll walk through. Again, they're examples, I guess, to illustrate around each of those 4 areas of liability. So the first one is the risk of property damage and personal injury. In the first column, I've given some examples, and in the second column, it's about the particular policy that is appropriate for that kind of risk. And bear in mind that the cover available from insurance is always subject to terms and conditions and various exclusions. But this gives you a broad starting point to make sure that you're matching your insurance to the risks that your business faces. So firstly, accidental injury. That's something that's commonly and well understood, and we have ACC insurance in New Zealand to cover that. So there's no other insurance that's really necessary in a large part where accidental injury is involved. Secondly, you've got accidental, and by that in insurance terms, generally taken to be sudden, something that's sudden, something that was unforeseen from your perspective, and obviously unintended. And that's results in loss of or damage to a third party's property. And that's really the fundamental insuring clause, if you like, of public liability insurance. You've accidentally damaged someone else's property. That's a public liability insurance claim. Next, it's injury or illness to third parties that's not covered by ACC, and there are some gaps in ACC. So obviously, if it's illness related, then it isn't an ACC claim, because ACC is about accident. And if you're found liable for that, then you need to understand what insurance is available. So if it's injury or illness to a third party and ACC doesn't cover it, then public liability insurance has some cover in there for personal injury. And that doesn't include employees though. So if you're held liable for illness or injury to employees where ACC doesn't cover it, then there's a policy called employer's liability insurance. And that really just plugs the gaps where ACC doesn't sufficiently cover your liability as an employer for injury or illness to employees. Secondly, the liability risk of financial loss to a third party where there's no property damage. So for example, if a third party alleges that you have caused them some kind of cost, financial cost, as a result of your action or a mistake you've made or something that you haven't done. And that's, as I talked about earlier, where errors and omissions indemnity or professional indemnity insurance comes in. So for example, someone's alleged that the work you've done is not fit for purpose. And that's a phrase that's in the Building Act. It's also understood from common law. So someone said that the work you've done is not up to standard. Now that's not a public liability claim because it's not a physical, accidental property damage. But someone's alleging that they're out of pocket because of something you've done. So that's, again, errors and omissions indemnity. Now, if the allegation is that the work is not fit for purpose because of materials, that's going to be very difficult to cover under any form of insurance, because insurers are reluctant to cover your liability or the liability of a materials supplier. However, if you have a 10-year guarantee, and it's one of the ones with the waiver of subrogation, or what's more commonly known as the liability protection for the builder included, that potentially can indemnify you for liability for faulty materials. So the insurer would pay that claim, and then they would seek recovery from the materials supplier. So again, a good reason to put a 10-year guarantee on a residential building project. Another example could be where yourself or one of your subcontractors or staff has failed to follow a specification correctly, or potentially substituted something or misread something, misinterpreted something. Again, and maybe that requires rework or fails an inspection and fails to get CCC. You're held liable for the costs from the client, and that's where errors and omissions indemnity insurance would fit in. And perhaps your subcontractor or makes a mistake, and we've had examples, as I may have mentioned, where the foundations have been laid in the wrong place. A consultant surveyor has marked out the site wrong, and the builder is held liable by the client for the cost of having to make that good. And the surveyor's liability to the builder has been limited in their terms of their contract to 2 times their fee. So the builder is stuck in the middle. And again, that's where errors and omissions indemnity insurance would typically fit in. In terms of fines and penalties, I'm conscious we're at 20 minutes now, so there's 2 or 3 pages to go, and I'll run through those quite quickly. Liability risks where you might a fine or penalty might attach would include perhaps contaminated site runoff, pollution into waterways, that kind of thing. Building without a consent, Health and Safety at Work Act breaches, and misleading conduct under the Fair Trading Act. So that might be things like putting yourself out there as being competent to perform certain work which you're not, or making price promises which you're unable to meet. And in all those examples, statutory liability insurance is the policy that covers the fines and penalties, except it cannot legally cover health and safety fines and penalties. For all of those fines and penalties, if they went to court, if something was prosecuted, and this includes health and safety, then the policy would cover the legal defense costs of that prosecution, including health and safety. And if the judge awarded reparations to an injured party, which they can do in an unlimited amount now on top of ACC, then the policy would also cover those reparations. And finally, liability risk around management. So as I mentioned at the top, directors are personally liable when a company collapses. then directors and officers liability insurance would cover them for their liability as directors in a case of trading while insolvent, for example. Also, where directors can be found personally liable for a health and safety breach, failing in their duty of care. Perhaps a former employee alleges unfair dismissal or discrimination. Then there's a policy called employment disputes liability, which would cover those circumstances. So quickly, just some key issues with liability insurance for you to be aware of. And the biggest one, I guess, is around faulty workmanship, which has been a bugbear for a long time. It's why we introduced it as an extension to our public liability insurance, because insurers were declining far too many things under the sort of excuse of faulty workmanship rather than it being accidental damage. The key point is that no single policy will cover faulty workmanship in general. It'll depend on the kind of loss that's been caused or that flows from the alleged faulty workmanship. And I'll explain what I mean. If the faulty workmanship causes physical property damage or loss, then it's a public liability insurance claim, provided your policy has the faulty workmanship extension. Because public liability is all about physical property damage or loss, accidental damage. However, if that faulty workmanship causes a financial loss only, then it's not a public liability claim. It would be under errors and omissions indemnity. So, for example, where maybe the wrong concrete mix has been used, or a flashing's been missed off when installing a window, or the cladding's been applied incorrectly, plaster's been applied incorrectly. All of those things which mean there's a problem with the work, but no accidental event causing property damage would fall under this side. Other key issues as we finalise this is what's considered to be your product, because under a public liability policy, your products will be excluded. And again, insurers can be tricky about this. So the house you built is your product to a lot of them. So any damage to that house would not be covered. And you'd have contract works insurance, you'd hope, but there are circumstances where this might be applicable. So that's something to bear in mind. Is what you're working on considered your product? And secondly, is the property you're working on covered? It's sort of similar thing. But for example, if you're working in the ceiling of someone's house because you're installing insulation and you put your foot through the ceiling, insurers have declined that claim because the ceiling was the property you're working on. So again, I guess to reinforce, liability is complicated, and there are issues with pretty much every liability claim. Other things to be aware of are that some policies have a building defects exclusion, which is essentially limiting the insurer's liability to pay claims if there's external water penetration. This is a sort of a post-leaky homes exclusion. So if there's external water penetration, rot or mold, your policy, if it has that exclusion, may not cover you. And what about your liability if there is no property damage or loss and you've only got public liability? So for example, a design defect, or as I've talked about before, a misread spec or substitutions. That's where a public liability policy wouldn't cover you, and that's where the errors and omissions policy would be appropriate. Finally, just touching on Building Act warranties. You obviously, under the Building Act, have a 10-year long stop liability. So it's just about understanding your duty of care under that Act and those warranties to customers, and that everything you do has to be fit for purpose, and making sure you have adequate insurance for that period of time. If 4, 5, 6 years down the line, a subsequent owner of a property you've worked on or built comes back to you, how have you minimised your liability in that case? A couple of other issues. Don't accept liability. That could prejudice your claim, because it's the insurer's job to determine liability once you, I guess, pass over the cost of the claim to them. So you can't admit liability. The best thing to say is, well, I'll contact my insurer. rather than putting your hand up. Even though it might be patently obvious, it's something to be aware of. Also be very, very aware of incurring any cost yourself. As I said at the top, liability policies are about the cost that a third party incurs and that they're holding you liable for. So if you start incurring cost yourself, the insurer might say, well, we don't have to pay that because you've already borne it. It's not a cost that the third party has had to bear. Now, we fight this all the time because the reality is with building work, sometimes you have to get in there and mitigate it or fix it or prevent further damage. We understand that, but just be aware of the amount of cost you're incurring before you make a liability claim, and assume that your cost will be reimbursed, because it may not be, because it's not a policy that reimburses your costs. It's a policy that pays the loss to a third party. Really, but in a nutshell, what I want you to take away is framework, I suppose. So consider your liability in each of the 4 classes. What's your potential risk around property damage, third parties to third parties? Your risk of personal injury to other people? What's the risk where you potentially make a mistake or someone makes a mistake on your behalf and it's a financial loss only? Defects, for example, materials, the specification, misreading, that kind of thing. Fines and penalties, straightforward, and management liability. So those of you who are directors, understanding that you have responsibilities from a management perspective, and if things go pear-shaped, that you personally as directors can be held liable as well. Secondly, do that risk assessment and understand what are your biggest risks by ranking them. Potentially a good exercise to do with perhaps a few other colleagues, or like as I said, with some advisors or other people. Just do a bit of a session, employees within your business, that'll help you to put that together. And thirdly, does your liability insurance cover the risks you're most concerned about or most exposed to once you've done that assessment? And again, once you've done that process, gone through that process, talk to your insurance advisor or us, and we can help you to make sure you've got the right cover in the right places.